for according to Ghana Tonight, Alfredo Kansi, Attorney General of Ghana, the Department of Justice no, ɔmo ba abɛyɛ changes bi wɔ mu because according to Deputy Justice and as a Deputy Attorney General, Parliament anaasɛ ɔmo yɛ mistake of prosecutorial powers no nti sɛ ɔmo bɛyɛ changes ɛwɔ what Attorney General's department in terms of prosecutorial powers nti no ebe zoom into Alfred Kansi na yɛakɔtie more details.
Children have been recovered. A dedicated team of divers and emergency responders, Deputy Attorney General Dr. Justice Edem Sremsai, has been speaking. And in fact, he told the Supreme Court earlier today that Parliament erred in using ordinary legislation to amend the Attorney General's constitutional prosecutorial powers. And this is in a matter with the special prosecutor. And we're going to put that on the screen right now. It just gives you an idea of how this has been playing out. In a statement of case for the motion seeking the leave of the court to extend the time for the Attorney General to file his defense. And we'll put that on the screen now. In the matter of a private citizen that's challenging the powers of the Office of the Special Prosecutor, the Deputy Attorney General argued that portions of the OSP Act is unconstitutional. And here is the reason for this. And we would clearly get into exactly what this really is all about. And taking into consideration, the Deputy Attorney General references the Article 88 of the 1992 Constitution, which spells out the power of the Attorney General, and then also the Section 4 of the OSP Act, 4.2 specifically, and then draws in why the position of the Attorney General in this matter, questioning Parliament's that decision, as it were, to now take those prosecutorial powers, part of it, to the Special Prosecutor's Office. Now, if you look at Article 88, and let's run through it very quickly. There shall be an Attorney General of Ghana who shall be a Minister of State and the principal legal advisor to the government. The Attorney General shall discharge such duties of a legal nature as may be referred or assigned to him by the President or imposed on him by the Constitution. Now, look at 3. The Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses. So take note of this. The Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses. All offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person. So just bear in mind 88, 3 and 4. That all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by the Attorney General in accordance with any law. So this is the meat and the basis for which the Deputy Attorney General is making that particular position quite clear in the push about the Office of the Special Prosecutor's law, that the law that establishes that office, giving prosecutorial powers to the Office of Special Prosecutor without clear reference to this, that it has to be upon delegated authority by the Attorney General. And let's bring in Martin Pebu, who is private legal practitioner on this matter. Counsel, good evening. Thank you for joining us here on Ghana Tonight. What's your reading of this matter? Because this has been playing out since last year up until now that we're having the Deputy Attorney General as also espouse this position.
Yeah, so, this suit has a certain context. You can't run away from the, let me say, tug of war, for lack of a better word, or turf war, yes, between the Attorney General and the OSP. In respect of the Kenofuriata extradition package. The OSP had a docket, the Attorney General asked for it, and for months on end, the OSP wouldn't release it. And then eventually they said, what they said is sufficient. It doesn't need the actual docket, all that. So you see that it was clear that there was some kind of, for lack of a better word for now, let's say insubordination, because the Constitution knows the Attorney General. Now, the Parliament, as a society, and let's not also forget, were frustrated by the fact that an Attorney General couldn't prosecute his colleagues in cabinet, etc. That's how come from the late 90s. The IEA led calls for an office of special prosecutor. We're kind of going back because in the 80s, we also had it. We had the same, well, not the same system, but at least a similar idea. So you hear Lawyer Appiah, who was the special prosecutor, or those days you say public prosecutor, etc. So, but the point I'm making is that, so the lawsuit and the provisions have a context. So it's because of that tug of war, right? That turf war that I believe feeds into this kind of lawsuits, etc. Yeah, and other comments. We've all commented before in the past. Should the office be abolished? Shouldn't it be, etc. But one thing is very clear. Look, we need that office. We need that office because generally we are looking for an independent institution. But right now the frustration has come in because the manager, Kisie Jabin, has a lot of conflict of interest. His relationship with Gabi Ochredako, Akufo-Addo's cousin, his relationship with Oforiatta, you see, and the way he allowed Oforiatta to flee Ghana, all those things. So that's what I said at first, and then they said, oh, they did that and arrested him. But we will not run away from it that, yes, the conduct of Kisie has brought a lot of stain to the office. We can't run away from it. Yes, we can't. Nobody can do any proper analysis. So you see that because of that, it tends to kind of cloud the lawsuit. But doing the legal analysis, pure legal analysis, what we would say is that, you see, Article 88, Clause 4 allows the Attorney General, right, to delegate power to other persons to prosecute. So as we speak now, there are prosecutors who are SNIT officers, SNIT, or Social Security and National Insurance Trust officers. They are prosecutors. They prosecute employers who don't pay SNIT. There is the electricity courts. So they are public prosecutors who are doing electricity cases, and they are not Attorney General people. Even we should have started with the police. Police, in the Constitution, police don't have power to prosecute. It's the Attorney General that gives them power. And you find the EIs from the 1970s. Okay, I'm sure even before 1970s, they would have been older ones because police have always helped to prosecute. So you look at police helping Attorney General to prosecute. You look at SNIT, electricity cases, forestry. You name them, there are more. Yes, even apart from this, there are more that they help to prosecute. So if you look at it in that context, then you say the Office of Special Prosecutor Act follows the same model.
But Ren, I just want to find out, counsel, what specific problem is this suit seeking to solve in practice and in the current execution of the structure of the law as we have it now? What problem is it seeking to solve? That's from where you say.
Section 4, right? Subsection 2. To paraphrase, I don't have the law here, but if you have, you can do. It says, among others, that the Office of Special Prosecutor shall be authorized. So the Special Prosecutor shall be authorized, right? By the Attorney General. Shall be. So now the question is, did we just give a one-time authorization in the Special Prosecutor Act 959, or it was meant that there would be more, some lawyers, Dafia Mepo will say, bring out regulations on how to guide and give consent. That's on how to authorize him that this number, let me check, or I will not check, etc. That's, I heard Honorable Dafia Mepo espouse that one. But it would appear that when we were passing the law. I remember Martin Amidu's time when he was special prosecutor, etc., the first special prosecutor. We intended to just make it independent, but we also accepted that without a constitutional amendment, we couldn't say that it was totally independent. So if you ask me, it appears we just agreed that, so kind of a consensus, right? So you kind of agree that, well, the Attorney General will not stretch his tentacles to touch the office of special prosecutor. In other words, the special prosecutor is free to initiate the cases. I think at the time we're thinking, and then we agreed, I think we kind of thought that we'll always get a special prosecutor in the mode of an angel. Yes, so at that time we didn't have a problem. We just thought that, oh, yeah, the special prosecutor should be allowed. The Attorney General shouldn't touch him. But the moment we got Kissie Ejade as special prosecutor with all the conflict of interests and the things we hear in town, which we will not mention here, but many people have heard, etc., then we said that, no, this is a big mistake. It's a big mistake. So then that's why I mentioned earlier that so you see lawsuits challenging things here and there, because now we've realized that, oh, the special prosecutor may not be an angel after all.
Right, Council, but this is what you referenced, the OSP Act 959, Section 4.2, and we're going to put it on the screen. Subject to Clause 4 of Article 88 of the 1992 Constitution, the office, that's the Office of Special Prosecutor, shall, for the purposes of this Act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offences. And the emphasis, mine, shall. Now, if you look at this, taking into consideration the exact summary of the Attorney General's position and his argument on the powers of the Special Prosecutor, and you've referenced a few already, the Attorney General is of the view that the prosecutorial powers of the Republic, as I read earlier in Article 88.4, vest solely in the Attorney General's office. 2, that the OSP Act does not compel the Attorney General to authorize the OSP to prosecute offences, as I read in Section 4.2. Now, Parliament cannot compel the Attorney General to authorize any person to prosecute an offence, and also that the OSP Act varies the Attorney General's constitutionally protected prosecutorial powers, as enshrined in Article 88.4. Ordinary legislation, according to the Attorney General's argument, cannot alter the prosecutorial powers vested in the Attorney General. And finally, that prosecutorial powers may not be delegated to a jurisdictional person. Now, if you look at all this argument, Council, and you draw in other matters that, to the extent that we've seen in the past, the Deputy Attorney General, Dr. Adam Shemsai, coming out publicly to say they've been asking for dockets, they are not getting, and then the OSP eventually makes it available, explains why there was a delay. All of those from your view plays out on why now the authority of the special prosecutor is being questioned on the matter of law and whether it alters the Attorney General's constitutional power of prosecuting cases in the name of the state. I want to find out from you where you see this going, because this is a matter that is playing out in the court of law. The prosecutor's office, which you say that is needed. We need that office to solve a particular problem. If we're going to now go back to where the special prosecutor will have to go to the Attorney General and then have cases of corruption-related offenses also either authorized before he prosecutes, is that not also creating a problem which we are trying to solve with the OSP's office?
We are thinking of how to, clip the wings. Yes, so it's normal because, based on what we've seen, that's based on the current tenure of TCAJ. I think it makes sense for us to look at it, whether we will do the regulations as Dafiamepo is as a majority chief whip is espousing, or that we will be saying that the cases should be taken to the Attorney General, which doesn't look clean. It doesn't look clean. That if the cases have to go and the Attorney General will look through like the Yoko one, that's how Yoko prosecutes. Generally, they have to take to the Attorney General for a fiat, so to speak, is concerned. If we have to take this OSP briefs to Attorney General for consent before he prosecutes to be honest with you, then we would not have made much progress. So we would have to perhaps go with Honorable Dafiamepo's model, where they try as much as possible to give out the guidance, the things to follow. Yes, the things to follow. Because I remember that myself in my, I don't want to go into my petition, but I know we have discussed the weaknesses of the office, the power of the special prosecutor to be able to suppress cases. So if Mr. Okansi is his friend and a case goes there concerning Mr. Okansi, he can sit on the petition, it doesn't go far, etc., which we thought no. In a modern special prosecutor's office, when the petitions go, it should go to a committee so that you all sit down and see it, so that no one person can sit on it because Mr. Okansi is his friend, etc. Then they will determine whether they have the mandate to deal with that petition. So many other things we've talked about in terms of making it a stronger office. So this conversation, by all means, must go on. No, we don't benefit when we say we should keep quiet. No, we'll have to say it as it is, that now we've seen that no matter how beautiful your laws are, if the manager himself is not up to scratch, if he has too many conflict of interest, etc., and with time, we'll get another special prosecutor who will come with different problems. So it's becoming clear that we need to evolve the system to be able to quickly catch up with the frailties of each special prosecutor. Yes, that much is clear. It's clear. I mean, it's very clear. Sorry. You say it. So that is what I'll say. That to conclude, in the law, yes, by the Constitution, we know only the Attorney General, but also by practice, from what I've said, there are many laws, the Slate Pensions Act, the electricity ones, forestry, all those things, the Act 30,